right, we are back. So, the last video I just completed this evening, a lady donated a significant donation, and because of her generosity, I want to expand and capitalize on how to build a proper claim. And again, I just want to extend a great bit of gratitude to the gal who sent a pretty sizable donation, and I appreciate that. And because of you, I'm going to do this video. So we were talking about how to enforce your claim. Well, I left out a few key elements, and not because I was trying to be deceptive in any way or to save it for later to bring you back into a class. It was just simply because in my train of thought, I overlooked a couple very, very valuable steps. There's a thing called chain of title, okay? And chain of title, for example, in the manufacturing of this tool, there will be a chain of title of who manufactured this piece here, you know, who manufactured the clutch, who manufactured the motor, and there'll be a chain of title all the way to identify this piece and what it took to manufacture it, and then thus becomes a serial number, okay? And to this day, I can go look up the records of where all these pieces came from and the inventory list and when it was manufactured, okay? That's called chain of title. And it's very, very, very important, because if you have a breach in the chain of title, I'm not saying you can't prevail, I'm saying you've created an obstacle for yourself. So when we're thinking about bringing a claim, when we are either one, mailing out our correspondence via registered mail with return receipt required from the man or woman it's being sent to. That's one way of service of process that is valid, and again lends to chain of title, proving with your registered mail number. Obviously this is not a registered mail number, but proving with the numbers that tie the chain of title together, okay, which would be your registered mail number. Now, when you send out your first correspondence, there's a second way that you can do it that is advantageous for proving chain of title, and that is having what is known as a notarial process of service, having a notary who has been witnessed and authorized by the state to execute certain performances, okay? And they're under contract to do so. But in order to validate it, and I learned this the hard way, you have to pay them for their services. If they do it for free, out of the goodness of their heart, it can be dismissed. And I had it happen to me with firsthand knowledge. I can testify that that's why the claim was thrown out, was because I had a friend who was a notary do the service of process, and the question then and there became, did you pay them? Did he pay you? And she said no. And that right there threw the whole thing out, okay? Because they're supposed to be non-biased, nobody works for free, involuntary servitude shall not be had. You're charging them with a duty, it's a contract you're entering into, and there must be valuable consideration exchanged. You want something, they need something, all right? So cover their gas. You can make a private agreement of whatever the cost is going to be. That's between you and your private server that's going to do the private administrative process of service, okay? Or you can hire out the sheriff's department. Now, I've caught some flack in the past in different states where they go, well, that's not our job. We don't have to do that. Horsepucky. I'm telling you right now, they have a duty and an obligation to avoid controversy by stifling a process that is not only lawful, but legal. And then they would become a party to the action for failure to fulfill their duty and obligation, all right? So in the event that they refuse, you want to know what their rights, titles, duties, and obligations are. Because if you can find them to be breach of their duty, breach of their obligation, then you can also find them guilty of conspiring against you. All right. There's a number of different things that if they are derelict in their duty, that's breach of contract, breach of public policy, breach of their oath of office, breach of trust. Okay. There's a reason that we vote for the sheriffs in our communities. They're to uphold the law and maintain the peace. So that's another avenue you can go down, is asking for the correct form to have the sheriffs and the deputies execute process of service. Now, if they ever give you any riffraff and tell you, we don't do that, that's BS. They do it for banks all the time. They do it for the court system all the time. They do it for credit card companies. They do it for a litany of other things. So don't allow them for a minute to tell you that they don't have an obligation to do that. You want their rights, titles, duties, and obligations. And if you need to take it to the next level, then you can go into a data integrity board hearing with the county and find out what the rights, duties, titles, and obligations are of said officials. All right? No offense. How do we know? Say all this old Freeman, etc., isn't another psyop. I'm not following you, Tyler, but I'm just here simply showing how to administer a private administrative process to enforce your claim. That's it. That's all I'm doing. So, and it's due in part because a lovely lady made a sizable donation, and I was sitting here doing some studying and realized that I left out some very, very key components to making a claim and being able to uphold it. And so the next step after your process of service is making sure that you get a certificate of service, which again lends to chain of title. I create the instance that occurred, okay, what transpired after it, the violation, the harm that was being caused, and then we have the body of the situation that occurred and all its little components that are inside. And we have chain of title through our process of service, okay, and we're tying all this together, and at the end we're going to have a solid piece of equipment, okay, to secure your rights, to find that remedy for you. After you send out the first notice and opportunity as a polite correspondence with all your evidence in support of your claim for the harm that's been caused by way of trespass, okay, then what you're going to do is you're going to allow them. You can allow them 30 days. You can allow them 21 days. When I was studying the land patent, for example, it's 61 days. It's considered efficient and adequate notice, 61 days. So you can give them 61 days if you want. You started the process right away, so you're not, equity's not going to say that you weren't vigilant and didn't stand upon your rights. Equity's going to look at it and go, okay, got a process in motion. So if you feel like giving them 61 days, then that's way beyond a reasonable doubt that in 61 days they should have more than enough time to rebuke or dispute what you're stating and the evidence that you've submitted to them. All right? Now, let's say you give them 30 days, and at the end of 30 days, they don't respond. If you have a third party involved as a process server, the addresses for the respondent should be your process server, okay? And if they want to send you a copy, that's fine as well. But if your process server doesn't receive anything, they're the non-biased third party, right, that prove your chain of title. And if the third party doesn't receive anything within 30 days from whence she sent out the letter, and you can give them 3-day grace period for the mailing, all right? We always want to administer grace where we can. And, of course, we can be compassionate if a tragedy had developed. We all know that we don't have complete control over Mother Nature when we go or when we're here. So, you know, within reason, death in the family, something like that, obviously is going to merit discretion, right? And we want to give what we intend to get. So we're going to give them the benefit of the doubt. When they don't receive anything within that 33 days, right? There's nothing being stated like, hey, I've got an emergency, a family emergency. I can't deal with this yet. I will respond to you. Okay? Then what happens is you issue a certificate of non-response. Okay? You create that certificate of non-response, and again, You have your private administrative processor who is either mailing this out or physically finding them, okay? And if you're using the registered mail numbers, you can't just let anybody in the household sign for it. It must be specifically them. And on the 3806 forms, you can require that they ID the individual, okay? They either know them with firsthand knowledge because they grew up with them and they happen to be the postmaster or whatever the case may be, all right? The certificate of non-response is critical because it shows that, first off, the letter was sent, and secondly, it shows that in the 33 days there was no response. And it's a third-party, non-biased individual that is making that statement of fact, okay? That's critical. Remember when we were reading the maxims early tonight and we were saying you can't be your own judge, jury, and executioner? All right? So you're removing yourself from the situation, putting trust with a process server to handle the affair. But we know most notaries, most process servers are never taught the actual law and chain of title, okay? So you have to do your due diligence and make sure that you are following due process of law and making sure that you're iron tight all the way through. All right. The certificate of non-response is huge. Okay. Then you send out your letter of your correspondence and notice of intent to sue Neely DC. Remember, your first correspondence was just merely, hey, whether you inadvertently had done something or you knowingly, willingly, and intentionally did something, your actions caused a trespass against my unalienable rights, causing I, a man, harm. And there's compensation that needs to be, there's remedy that needs to be had. Most people attribute remedy to FRN notes. Many don't think about the other options. You may just need somebody to mow your yard for the next 3 months. Maybe that's adequate remedy. And for an hour every 2 weeks out of the summer, they're going to come over and mow your yard to make you whole again. And that provides remedy. It doesn't necessarily have to be an FRN issue is what I'm trying to say. It could be gold. It could be silver. It could be a quarter of a pig. It could be beef. It could be bacon. It could be bread, okay? Don't limit yourself. Because there are things in this world that are way more valuable than an FRN note, which is an instrument of debt, okay? If I was in, let's say, Ethiopia, and I had a cheeseburger and 5 1-ounce silver coins, but the kid's hungry, what do you think he's going to find more value in? Does he think the 5 silver coins are going to fill his belly, or does he know that cheeseburger right there is what he needs? So if I trespass against the Ethiopian, he gets the choice of what the remedy is. And then I have to try and fulfill it if it's possible, right? So FRNs aren't always the answer. The next thing is going to be your notice an opportunity with the intent to sue Neely DC, because you gave your first polite correspondence to get remedy, to avoid controversy, to bring to light all the facts and evidence that you have for bringing your claim. All right? And once that has been ignored, and you have a notice of service of process that's been signed, and you also have a failure to respond notice that's been signed and witnessed by your process server, whether it be the sheriff's department, whether it be somebody you pay that's a third-party, disinterested, non-biased individual, right? Or whether you use a notary, okay? It's important that you know these things, because they're not going to, and they're not going to aid you in doing this. If you don't know what you're doing, chances are your process will fail. So the intent to sue Neely DC, which means he says nothing. Okay, now we've escalated from a polite correspondence to the intent to sue for the breach, for the trespass causing you harm, right? For which you understand what the remedy is, all right? We want to be reasonable, obviously. You know, we're supposed to forgive those who trespass against us because we would expect the same, especially if it was by mistake, all right? Give them 20 days to respond, 21 days to respond for your intent to sue. In your notice with your intent to sue, you should probably outline that you're willing to testify in open court on record to the facts, and you will prove it in open court. Everything that you have made your claim upon, you're willing to do that. And if you have to go as far as holding a court of record, that you will also be seeking the costs as well. Okay? It's not a threat. It's just outlining the parameter for which you're going to operate if it has to go any further. Right? If you've been wronged, you don't need to be told that you're wronged. And they know that they've done wrong. And maybe they don't. Maybe they don't. So that's where the declaratory judgment comes in. You get in there, you see what his rights are in equity, you see what your rights are in equity, and if you executed your private administrative process properly, I'm telling you right now, I heard this from a guy who's getting his judgeship right now in Yale University. He said, Derek, I'm going to give you a $40 million gift. It's called Neely DC. And he hung up the phone. Okay? I looked into Neely DC, and within 5 minutes, I'm back to messaging him going, man, that's brilliant. Thank you so much for that gift. Because Neely DC just simply means he says nothing. And he went on to exclaim that 99.9% of suits brought Neely DC are immediately rubber stamped. So I had to start thinking about why that would be. Well, if you follow due process of law, Neely DC is clear as clear can be. He says nothing, which means he acquiesces or he agrees by tacit agreement. His silence is agreement. Remember, we were talking about that in those maxims. So I messaged him back. I was like, I got it. I got it within the first reading just what Neely DC was. He said nothing. I immediately got back to him. He goes, wow, that was quick. You do know some things. So what I'm sharing with you is even recognized at the pristine universities, if you will, such as Yale. All right? And again, he's not a judge yet, but he is going to school for his judgeship, which means chances are he was handpicked and groomed, because they don't just make anybody a judge. You can go to law school. Doesn't mean that you're going to be a judge. I promise you that. They're handpicked. They're groomed for their intelligence. And then it's just a matter of figuring out how they can manipulate them to do what they really need them to do, which is fleece people. So after the 21 days and the 3-day grace period, remember, we're always going to give them a 3-day benefit of the doubt. It's good faith. We're operating in good faith with good conscience for good reason. Then we're going to send out our notice of fault. Our notice of fault, we will also do another non-response on. Maybe our notice of fault, we're only going to give them 10 days at this point to respond. Plus the 3 for a total of 13 for the mail, if they choose to respond back via mail. Because they probably won't hire a process server to bring the letter back to your process server. Right? And if you're using the mail, now you have the mail as your postmaster as your federal witness. Okay, so that's why the mail works so well. And I'll get into that in a minute, but I want to finish this process. Then you're going to do your notice of default with opportunity to cure. You're also going to complete a notice of service on that. Okay, and then you're also going to complete the non-response on that. At that point, 3110, and again, you can go statutorily and look at it, but 3 days creates a contract, ladies and gentlemen. I'm being very gracious. If somebody accosted me against my will and violated my rights, I'm being gracious giving them 31 days, okay? If you want to go statutory with it, so be it. Go look up the statutes for it. I'm sure it's better than 21 days. But when I get to the letter of default with the opportunity to cure, 10 days is more than fair, all right? Especially when I have either their green return receipt or the fact that the notary will testify under the pains and penalties of perjury that she did in fact serve said man or woman who caused harm, who's the wrongdoer, who's the respondent, who isn't responding, okay? No response. You don't have to create your declaratory judgment and send it to them. I'm just a nice guy, and I want to see equity flourish. So I'm going to let them know I've just created my own order due to your non-response, which is an agreement by tacit agreement Your silent acquiescence is confession and avoidance. You're confessing that you know you did wrong, and you're absconding from your responsibility, which is causing another trespass by way of debt, which brings another claim and another action following due process of law. Very simple. Notice an opportunity is due process of law. Okay, you have to be able to articulate the who, what, where, when, how, and why. Okay, because the onus of probandi is on the claimant. You're the claimant, they're the respondent. The respondent inferior, they're the man or woman that's the respondent. And we're always going to address them as the man or woman in the claim, who sometimes or who at times acts in a certain way. Remember, an act is nothing more than an actor doing something, right? Okay, so they're actors, and they act a certain way according to their policy. Policy is not law. The legislator may tell them, you can do that, but what they're not telling them is by doing that, they make themselves liable for breach of public trust, breach of public policy, breach of the oath of office, okay? So the legislator says, oh yeah, you can accost people against their will, and then he just kind of turns around and walks off. Is the legislator responsible at that point for what another man does under color of law because he said you can do that? No, he doesn't, because the man ultimately has a duty to know, okay? Just like you can tell a 3-year-old they can't stick tweezers in a light socket or in the wall socket, you can tell them all day long. The first time they do it may just blow a breaker. Second time they do it, it might bite them a little bit. I bet they won't do it a third time after that happens. Some lessons are only learned painfully, all right? And at some point, you're going to have to hold them accountable because they're not going to stop. Just like a dog that you don't properly train who keeps urinating and defecating in your house. If you wait for 5 years to scold him and rub his nose in it, you're the one to blame, not the dog. You, for not taking effective action when you should have. And now you got a dog that's 5 years old that's an outside dog, not an inside dog, obviously. All right? We're responsible for this nightmare, this mess. But we can fix it. That's the beauty of it. So that's how you execute your chain of title to create something of substance that you can stand on. Chain of title, witnesses to verify and validate, and you can hold your own court. And when you do this, if it's a suit brought properly via Neely DC, okay, which means he says nothing. I have a man going to Yale University right now for his judgeship. He's not far from being done and being a judge. Whether he's going to be a federal judge or a county judge, I don't know. I'm guessing if he's going to Yale, he's going to play in the big leagues. All right? I don't think he went to Yale University to go work at some podunk county. But then again, I could be completely wrong. But I'm here to tell you right now, he was telling me 99.9% of Neely DC suits that get brought before the court are immediately rubber stamped. The only thing they're looking at is, did you follow due process of law and bring it proper? They're very militant. Okay, military, Admiralty, maritime law is all about process. Everything they do. If you're going to open a box, for example, you pull out your knife first, you open it away from your body, you never cut towards your body, you cut away. I mean, they're very, very methodical about what they do, allegedly, to be efficient, but we know how most often it's not very efficient to follow those guidelines. However, in the process of due process of law, they absolutely have to follow that, without question, okay? They may make an error. Highly unlikely. Like you told me, you bring a suit Neely DC, Derek, and you know what you're doing, they'll stamp off on it, not some of the time, every freaking time, unless there was a flaw in your process, unless, and he didn't say this, but I know this, unless you didn't do your certificate of process of service, unless you didn't do your non-response certificate and create it for each process you did. All right? So that's my gift to you from a lady that donated to me through Venmo. Greatly appreciate it, and thanks for your time. Thanks again to everybody that contributes to selfgovernanceu.com. It helps me do the literature, the research, the extensive studying it takes to ascend to the mind, to bring it to you guys in layman's terms. Remember, if you hire an attorney, you're a ward of the state, you're mentally incompetent, and of unsound mind. There was a child custody dispute, and it's funny because the only thing they had to say is, Your Honor, he's incompetent. The judge says, Can you prove that? She says, Yeah, he's got an attorney. Arrest my case. Really don't need to say anything else. He's not competent. He can't handle his affairs as a man. He's got to hire an attorney to speak for him. He's a ward of the state. He's of unsound mind. Are we really disputing the custody at this point? This is benign. Just think about it. Corpus Juris Secundum, Volume 7, Subsection 4. Black's Law Dictionary tells you what lawyers do, who they represent, person, places, things, and incompetence. Men and women of unsound mind that have no idea what's going on. Case closed. I rest my case. Got counsel. Can't believe we're even here trying to deliberate over this when your own literature tells you, and you have a duty to know, that if you hire an attorney, you're incompetent. You really want my offspring with that guy? I sure don't. All right, thanks. We'll see you soon. Appreciate it. See you at selfgovernanceu.com.